This is the third installment on our guide to processing a criminal case. And in this installment, we're going to talk about pretrial motions and hearings that may occur before your case actually goes to trial. This usually occurs after the investigation is complete. Then we decide what, if any, motions will be filed. Those are usually called pretrial motions, and they're not done in every particular case. Pretrial motions are usually motions that challenge some particular piece of evidence or some type of evidence. One of the more common ones is a motion to suppress, and that's a motion that is aimed at a specific item of evidence in a claim that it's illegally obtained. The most common one involves traffic stops, where you're claiming either that the stop was not proper or that the search that recovered the evidence was not proper. And so you're trying to keep that evidence out because the proper procedures weren't followed. Obviously, if you're successful on that, that can dispose of the case, because if the motion is suppressed, the state may not have a case to prosecute. Other types of motions can be motions that are aimed at particular types of evidence. Examples of this might be a confession or statement that you gave. Certain procedures must be followed for that, and if they weren't, then you may file a motion to keep that out. A lot of people think that motions for discovery are filed in every case, and that's not always the case. Now the state is required, on request, to provide whatever they have in their file. There are a few exceptions, but generally they're required to basically give you what they have. There are certain kinds of evidence that may require a motion, and so you may have to file something and get an order from the court to get to it. Things like medical records are not generally discoverable without some type of court order. Telephone records are another example. And sometimes it may be an item of evidence that the state doesn't have but that you want, and you're going to have to file a motion to get that. Another type of motion is a motion for experts. In some cases, especially cases where you're either indigent or you're being represented by a court-appointed attorney, they may file a motion to have an expert appointed to assist in the case. That could be a psychologist, a psychiatrist, a mitigation expert. They have to be necessary to dispose of the case, but if you're indigent and can't afford to hire an expert that you would be able to hire if you had the money, then that motion may be appropriate. There are also notices that your lawyer may file. There are certain things that the state has to provide notice of, but they only have to provide notice of it if you ask for it, which is when you file a request for notice. Things that you'll generally ask for are whatever experts they plan on using. If they plan on using evidence that you committed or were involved in some extraneous offenses, they'll have to provide evidence of that. And then statements. Sometimes statements of certain witnesses, you may ask for notices of those. So what happens if you file these notices? Generally you're going to have a hearing, and a hearing is not what you see on TV, and it's not even close to a trial. Hearings on pretrial motions are before a judge and not a jury. You may or may not have testimony, and the motion is generally limited to the specific facts of what you're trying to get or what you're trying to ask for. Usually the facts don't come into play much except as it relates to what you're asking for. You may have evidence. You can subpoena witnesses just like a trial. Generally, in most motions, you're going to appear and you're not going to testify. There's several reasons for that. One is it's usually not necessary. And two, you don't want to get on the stand and tell your story and then have that available to be used against you later if your case does go to trial. Hearings are not done in every case, but sometimes they are necessary. Some courts have what are called pretrial hearings. They have these in some county courts, even in some district courts, and they're labeled pretrial hearings. But just because it's labeled a pretrial hearing doesn't mean anything's going to actually happen. Most of the time the courts will set these hearings for the purpose of deciding any motions that need to be decided and for the purpose of finding out if there are any motions that need to be resolved or decided. If you don't have any, you're still going to have to show up in court, but your court appearance will be pretty short, and your lawyer will say is that you don't have any pretrial motions that need to be resolved. So that's a general overview of pretrial motions. If they apply to your case, and if we're going to file any, we'll discuss those with you and make sure you understand what we're trying to do.